All right. Good morning, good morning, good morning. If you can hear me, just type a Y in the chat. Good morning. Oh, great. Great. Yeni, you're welcome. All right. So we'll just quickly start in the interest of time. We need to be out of here in 1 hour exactly, right? So my name is Tony. I'm your host for this month's knowledge sharing session. You're welcome to the knowledge sharing session for the month of October. And this morning we are discussing the Nigerian Data Protection Act, specifically the newly released General Application and Implementation Directive, right? I think it came out sometime Q1 or Q2, and there's been a bit of buzz around its use, the implementation, and all of that. But I won't bore you with some of the things we've already said in the intro, the importance of this to how we manage data in our individual organizations, right? This morning, we are thrilled to have Bukola speak to us. Bukola is a GRC consultant and a data protection expert, right? The beautiful thing about her is that she has an exceptional eye for detail. Her impact spans across Nigeria, Africa, and even in the UK, where she has helped organizations strengthen their governance, risk, and compliance frameworks, right? Especially around information security, which data is part of. She's a certified data protection officer. She's a certified information systems auditor and has got a bouquet of certifications around implementing and auditing implementing management systems, especially the information security management system. It's a privilege to have her speak to us this morning. I think she spoke to us sometime last year or 2 years ago. So let's put away distractions and get ready to tap from her wealth of knowledge. So Bukola, over to you.
All right. Thank you, Mr. Anthony. Good morning, everyone. Please, I hope I'm audible.
Yes, just hold on. The way we would run, right? If we have any burning questions around this topic, we can drop it in the chat. We will give ample time to answer some of those questions. Anyone that cannot be answered, for those of us in the community, that feedback will be provided, right? But we will give ample time, say by 9:45 or 9:50, she would have wrapped up, and then we would have time to take questions, right, and contributions. Okay, Bukola, yes, over to you now.
All right, thank you, Mr. Anthony. I hope I'm audible.
Yes, you're loud and clear.
All right, thank you. All right, okay, so once again, good morning, everyone. Today, I'm just going to walk us through briefly, because the act is very voluminous, and also the implementation directive as well. But I'll just walk us briefly through getting our compliance rights with the Nigerian Data Protection Act. And for today's session, I'll just basically introduce you to the directive, touch a bit on the article and the schedules that has been developed by the Commission, and then we'll discuss common implementation pitfalls of the Act that we have that basically I and a couple of other people have observed from organizations regarding the implementation of the Data Protection Act. And then based on what we discussed, we would outline some basic mandatory data privacy check that you should do as a professional in an organization, and then would have some concluding remarks. So not to waste too much time. So sometimes around, I think that was March 20, and that's this year, the Nigerian Data Protection Commission released the General Application and Implementation Directive. And the essence of this directive was to give organizations who act as data controller or data processors, to give them a practical guidance on how they would achieve compliance to the Act. You recall that when the Act came in 2023, when it was signed into law in 2023, we've gotten several interpretations as to what is required by the Act. But now the Commission has come with this directive to say, oh, this is the expectation we have of you regarding all the requirements as stated in the Act. So this GAID, this directive became effective September, so which means that today you are expected to comply with the requirement of the implementation directive, and you must show appropriate, you must be able to demonstrate compliance and show that you have the appropriate measures to comply with the Act as well as this directive. So we'll just go right into the structure of the GID. Now, the GID has two sections. It's made up of 52 articles and 10 detailed schedules that support some of these articles. Now, for the first to the fourth article, it borders more on the scope, the priority, and also the cooperation of the Commission. So in terms of the scope, now it provides into detail what the scope of the Nigerian Data Protection Act is. I understand that right now, in terms of the Nigerian Data Protection Act, for the scope covers, first of all, if you are an organization that is domiciled in Nigeria that is processing the data of data subjects in Nigeria. So regardless of their migration status or their nationality, as long as you are processing data subjects for those domiciled in Nigeria, you must comply with the Act. Now, another scope is for organizations that are not domiciled in Nigeria. However, they process the personal data of Nigerians, of data subjects in Nigeria, of Nigerians, or they target data subjects in Nigeria. The Commission, the Act also applies to such organizations. So in light of this, it means that all multinationals that provide services or that processes personal data for Nigerian citizens or also those in Nigeria must now comply with the Nigerian Data Protection Act. And it gives the Act a global recognition such that you must, as a multinational, if you are going to process personal data for Nigeria, for people domiciled in Nigeria, you must take into cognizance the Nigerian Data Protection Act alongside the GDPR and any other data privacy regulation that you might need to comply with. Then it also borders on the priority of the Act. So when it comes to things that has to do with data privacy, the implementation directive is saying that the priority will be given to the Act in terms of data privacy and also the right and freedom of data subjects. So if you have to consider maybe two different laws, right? The Nigerian Data Protection Act must come first in terms of priority when you are considering anything that has to do with data protection or data privacy of data subject that you'll be processing. So, and then lastly, it speaks to cooperation. So cooperation is, they will collaborate with other agencies and bodies just to refine their data protection regulation so that it aligns more with the Nigerian Data Protection Act as well as this directive. Then in addition to that, it also gives the Commission the power to scrutinize some of these guidelines that a number of government bodies put out, meaning that you can't just put out anything that inflicts or that is a deviation from the Act. So the Commission can caution or scrutinize or even penalize such government bodies if their requirement is infringing on data protection requirements that has been stated in this directive as well as the Act. Then in terms of general, for Article 5 to 10, we're looking at general compliance and registration. So in this article, it speaks to those that are exempted. I know that faith-based organizations, some government judicial bodies and some government bodies are exempted from this act. However, the commission is now saying that although you are exempted, you must still comply with certain sections of the Nigerian Data Protection Act. Your processing must align with the principles of data processing. You must uphold the data subject's rights, among many other things, right? But just because you're exempted, it doesn't give you the right to do whatever you like with the personal data that you collect. So you must also apply certain principles, and where you fail to comply, the commission also has the right to sanction such institutions. Then, still on 5 to 10, it discusses in detail and classifies data controller of major importance. So there are 3 levels. You have the ultra high level, which categorizes commercial banks, be it regional or national level, fintechs, telecommunication, and many more organizations under this category. And then it puts a caveat that if you process personal data of over 5,000 data subjects within 6 months, you are also to be categorized as an ultra high level data controller or processor of major importance. So if you don't fall into the bracket of the industry that has been listed, the category of data subjects that you process within 6 months can also be used to classify you into any of this category. So for the extra high level, really typically covers majority of the government bodies that are applicable to the Nigerian Data Protection Act. And then the caveat is 1,000 data subjects within 6 months. So if you don't fall into the category of ultra high or extra high, as long as you process data subjects totaling 1,000, right, you fall under the caveat of extra high rather. And then we have the ordinary high level. And for the ordinary high level, we have schools, right? We have schools and other institutions that are listed there. And then the caveat is processing data subjects from 200, but not up to 1,000 data subjects within 6 months. So you'll be classified under the ordinary high level. Now, what are the reason for all this benchmark is also for regulatory compliance as well. So I understand that for the ultra high and the extra high, now you are expected to register with the commission just once, right? You register once and then you must file the compliance audit returns annually. That's in terms of compliance. For the ordinary high level, now you're not expected to do the compliance audit returns, but you must register with the commission on an annual basis, meaning every year you must register with the commission under the ordinary high level. And then it also speaks to the mandatory mandatory compliance audit returns. And this just goes into detail on what is expected for the extra high and the ultra high level data processors or controllers. And in addition to that, the commission has also created a mandatory schedule that will be used for filing these returns. Then also, based on this general compliance and registration, the commission repealed the Nigerian Data Protection Regulation, meaning that as of today, there is nothing like the Nigerian Data Protection Regulation. However, all the compliance activities that you've performed prior to this act, prior to the regulation no longer existing, they still suffice, right? It doesn't negate it. But what the commission is saying is that from September 2025, there's nothing like the Nigerian Data Protection Regulation. So you want to review your documentation, you want to ensure and align with this new directive. But any compliance evidence that pertains to the NDPR that you still want to maintain prior to now, yes, you can keep that. But in terms of your processes, your notices and things like that, you want to ensure that you update everything and then just focus on the Nigerian Data Protection Act and the GAID. So that's that bit. Then Article 11 to 14 speaks generally to the data protection officer, and it basically covers how to appoint the data protection officer, ensuring that the data protection officer that you appoint has the required expertise and is knowledgeable about the local laws regarding data protection and also global best practices regarding data protection as well. It gives, it empowers the data protection officer because it ensures, it puts the responsibility on the data controller to ensure that the DPO has all the necessary resources to perform its primary duties. Also, it mandates the data controller or processor not to coerce the data protection officer into for basically performing their function. So you as a controller or a processor, you're not expected to coerce or give penalty to a DPO that has performed their duties as a data protection officer. In addition to this, and the good thing about this section is that if you look at the Nigerian Data Protection Act, the section that speaks to the DPO did not really put into details what is expected, right? But that's why this is a good development because it now it empowers the data protection officer and it also provides context as to what is required. So take, for instance, the Act did not even speak to conflict of interest, but now the directive is saying that you can allocate other responsibilities to data protection officer. However, it must not conflict with their primary duties as a data protection officer, meaning the organization has to go back and review the position of the data protection officer, identify any conflicting duties, either remove those conflicting duties or reassign another data protection officer. Although this one is not new, but the commission gives you the liberty to appoint in-house or use an external consultant, whichever suits your organization. And then also they introduce the annual credential assessment. So they are saying that as a data protection officer, you must be certified. You must have certification from a recognized professional body, and the commission themselves would be doing this annual credential assessment where they will be validating your competence to still remain as a data protection officer. You would also be required to register with the commission as a data protection officer for an organization, some of which will bear cost by the organization that has appointed the DPO. Now, speaking to the lawful basis and processing, so if you look at Article 15 to 26, you see that it covers the lawful basis and processing. And then it just dissects the principles of data protection, the 6 lawful bases of processing, also the requirements for consent, cookies, and necessary assessments like the legitimate interest assessment. So we'll look into that in the coming slides. I'll just brush through this. So for articles 27 to 33, that one focuses more on risk management, carrying out assessments, ensuring data security, and also the requirements for data breach. Now, the Act mandates that when you're carrying out new processing activity that might result in high risks, or you're trying to use a new technology solution that might likely impact the freedom and right of a data subject, or you are processing highly sensitive data, you are expected to carry out a data privacy impact assessment. And the Commission has also created a schedule for that. So that way you understand what is expected when carrying out this privacy impact assessment. And you can use that as a basis for processing or to stop processing that activity. Another thing to note, although still not new, is that when you carry out this assessment and it results in a high risk, you are expected to report to the Commission before starting that processing activity. If the Commission doesn't give you the go-ahead, do not carry out that processing activity. And then the Commission also advises that if you do the assessment, you've done everything to try to mitigate the risk and it still persists, it is just best to stop that processing activity and find another way to carry out that thing, but do not go further with that processing. Then in terms of monitoring, evaluation, and measurement. So the Commission is saying that in terms of data security, you must have a schedule for compliance, right? How you want to monitor your systems, how you want to ensure that they are optimal, they are secured, and they have the necessary technological measures to ensure compliance with the Act, including things like enforcing the right to delete, amongst many other things that is expected. Then the Commission has put the caveats in terms of sensitization and training on privacy. The Commission is saying at least on an annual basis, train your employees, let them know their roles and responsibilities with respect to data protection, with respect to complying with the Act. You might want to create like a schedule explaining, giving them like a checklist, let them know what they are expected to do depending on the role that they are taking in the organization. And then for breach requirements, still the same thing, but there's just an additional caveat, which if the Commission should inform you, an organization who is either a data controller or a processor, and the Commission informs you or tells you that, okay, there's a particular individual or entity that is misusing your platform to infringe on data privacy rights, you're expected to immediately comply and stop that processing pending when the Commission investigation is concluded. And failure to stop that processing activity would hold you as a controller liable, meaning that it will be taken as you perform the breach yourself. So organization needs to also take note of this when they are assessing their privacy compliance as well. And then in addition to the normal requirement, which says that when you identify a data breach that can result in the risk to the freedom and right of the data subject, that's a high risk, you have 72 hours to inform the Commission, and you must inform the data subject immediately. Keyword immediately. And then we go to Article 34 all the way down to 44, and that one is speaking on rights, ethics, and emerging technology. So for data processing agreements, the Commission has stated clearly what they expect to see in a data processing agreement between a data controller and a data processor. And you are expected to ensure that all these requirements are in your contractual agreements with the data processor. It also speaks to the data subject rights and how you're expected to comply, what is required. Also, it introduces the standard notice to address grievances for data subjects where they can so there's a standard template under one of the schedules where you, as a data subject, you have complaints, you would use that template to basically note your grievances. The Commission is expected to build a portal where you can make those complaints, but I'm not sure as to when they plan to bring out this portal. But also, data subject can send this grievance notice to the data controller, and they must inform the commission, and then the commission would address or investigate where necessary. And then also some compliance requirement for emerging technology, like carrying out a DPIA, and just basically ensuring that the technology that you're using consider the rights of the data subject, ensuring that all the key principles of the Nigerian Data Protection Act is embedded into it as well. And then lastly, for the final provision, it just gives guidance into cross-border data transfer. So the commission, in terms of cross-border data transfer, there are some the commission has a list of countries that they deem fit as having adequate protection, or maybe they have like a similar data protection standard that is effective, right? And that way the commission agrees to the fact that, okay, you can transfer those the personal data. But please know that even in your transferring, it must still comply with the lawful basis for processing as well. And then it speaks to capacity building, ensuring that the data protection officer is trained regularly, and then they submit CPD credits to the commission. It also speaks to seeking redress rights in the High Court and the State Courts, and it gives some additional powers to the commission as well, and then defines some key terms. For the sake of time, I may not be able to delve deeper into everything. So we have basically the schedules. The first one that explains the principles of data protection, the compliance audit return template that is to be used by the ultra high and extra high level controller or processors of major importance. It speaks to the Schedule 3 is speaking to the DPO's assessments. That's the annual verification that the commission will be doing for data protection officers, I believe from next year. And then the templates for the DPIA, which is Schedule 4, and then additional guidance on cross-border data transfer, which is on Schedule 5. Schedule 6 is speaking to a data subject vulnerability index. So some of the risk factors you consider, and then also this would also help you in understanding how to develop your privacy policy and notice to address other non-literate customers or data subjects that you process their data. Then there's guidance on registration for the data controllers or processors of major importance, a template for legitimate interest assessment, the template for the SNAG, that's the subjects and data subject standard notice to address grievance, and then just basically a guidance on the audit filing returning fee. So I know that coming next year, the annual fee would change, right? Depending on the number of data subjects that you process their data, that will determine the amount you pay for filing. You can pay as much as 1 million naira for audit filing. So organizations need to take note of that and also include that, factor that into their budgets for the financial year in 2026. So now we would start to discuss implementation pitfalls. It's important that I say this. If you look at the GAID, you would see that there are a lot of pitfalls that you can pick basically by reading through each articles. One thing that I'm just going to do today is just speak to some of just about 3 common ones that I've noticed, and I think it's very rampant when you are assessing compliance, even before the guidance even came in and even after, right? So we're just going to discuss that, and then I understand that there's a masterclass coming up sometime soon that would basically cover the Nigerian Data Protection Act, is to dissect the Nigerian Data Protection Act, the GAID, and then give you step-by-step compliance checklist on how to ensure compliance with the Nigerian Data Protection Act. Another add-on to the masterclass is that you would you'll be given like generative AI prompts on how you can use generative AI to also improve your data protection compliance check to the NDPA, to the GDPR, and many more like that. So the first implementation pitfall we'll talk about today is the lack of appropriation of lawful basis. And then I highlighted this consent and legitimate interest in red because these are the two things that I want to talk about today. So one of the things that I noticed is that prior to the guidance, a number of organizations used to abuse consent and legitimate interest. And the first on consent is that organizations try as much as possible to, I don't know, would I call it dubious ways, right? They find different ways to get your consent or to negate your consent, right? You see cases like, take for instance, direct marketing. In the act, there was no clear cut on what kind of lawful basis you can appropriate direct marketing for. And then you see organizations say, oh, I'm doing this based on contractual relationship. I'm doing this based on legitimate interest. But thankfully now, the commission has said, in terms of consent, right, these 7 things, right? No, sorry, these 6 areas, right? No, it's actually, no, yes, these 6 areas, right? You must get the consent of the data subject, one of which is the direct marketing. And when we are saying direct marketing, what do we mean? Meaning that you send promotions to your data subject, either via text message or their email. So now, if you are sending marketing or promotions to your data subject or your customers or whichever category it is, you need their consent if it's going to be sent to their phone number or if you are going to be sending it to their email address. Now, I understand that a number of processing might have been happening prior to now, but what is expected is that as an organization, you take a look at your marketing structure, right? And the technology that is used. You want to ensure that you revalidate the consent for those that you've not gotten their consent for, because now the commission is saying that you must comply with this, and then you must be able to show that you got the appropriate consent from the data subject. So you want to go back, get the required consent from your data subject, and ensure that they comply and they consent freely, not that you enforce it or you coerce it on them to the processing of their data for marketing purposes. You want to also ensure that you make it easy for them to opt out, especially for direct marketing. You're not putting a caveat. And I think another area that organization needs to focus on is on the aspect of text messages. It's very difficult to opt out of text messages because there's no opt-in, opt-out what would I call it, opt-out mechanism that is in place. Although I know if you have like an RCS enabled phone, you should be able to implement this. But data subjects cover different areas. Some do not use new modern phone, but organization needs to consider all this and then ensure that depending on whichever category you fall under, they are able to ensure that they withdraw your consent where you have stated they should withdraw your consent. And then in terms of legitimate interest as well, initially you'd see organizations saying that, oh, their reason for sending direct marketing is based on legitimate interest. But now the commission is saying that you cannot claim legitimate interest just by saying so. You have to conduct a legitimate interest assessment. And in conducting that assessment, you have to look at 3 things. You look at the purpose test, right? Is my processing, is there a legitimate interest behind it? You have to also look at the necessity. Is it necessary to carry out this processing to achieve the interest? So you want to send marketing communication to your customers via text message. are you saying that there is no other means through which you can market this thing? I know that for those of us that were around during the time of 767 for GTB USSD code, I'm not a GT Bank customer, but I know the code. Why? Because they employed creative means for ensuring that everybody and anybody is aware of their USSD code. Now, that is marketing, and that means that if I look at it now, there are other means by which I can inform my customers, inform the data subject that, oh, I have these new products, I have these new services, and these are the benefits, and I want you to explore it, right? So the commission is telling organization, be creative, don't be lazy, don't just say, oh, because I have a relationship with this customer, then I can do this, I can do whatever I like. No, the essence of the Nigerian Data Protection Act is basically to give power to the individual, not to the organization. So when you are carrying out your legitimate interest assessment, you want to ensure that you are assessing it based on the rights of the data subject. Anything that impacts the right of the data subject, that your interest is more aligned rather than the interest of the data subject, the interest of the data subject takes priority in that case. And that's why that's why the commission is even now stating that for direct marketing, for child consent, for sensitive data, and some other things, right, you must get the required consent. So another thing to also note, right, just because consent is a lawful basis does not mean that you should carry out illegal activity. Article 20 of the GAID, it invalidates consent if that processing promotes atrocities, hate speech, child rights violation, and any other criminal acts that you can think of. So you cannot say that you are processing lawfully based on consent if you are engaging in a criminal activity. So that is very important to note that just because you got consent does not mean that you can now perform any illegal activity and then use consent as your basis for doing that. The commission is not going to take that lightly, and then you will be penalized heavily for it. So my next slide is just to buttress more on consent, right? Last weekend I went online on X, that's Twitter, and then I saw a tweet from one lady where she was complaining about a particular organization, university official, not remitting her money, that she's been complaining for over a month. She's not gotten any headway, right? And then what shocked me was when I opened the tweet, I scrolled down, and then I saw that the organization, that's university official, they literally were exposing the customers' information on the timeline, right? You can see now, they said, we apologize for inconvenience, and our customer success team is working to ensure all issues are resolved. However, to provide some clarity, here are some facts. Below is a transaction summary for Kehinde Odunola. Now, you are putting somebody's full name. You are talking about their account activity, a summary of their accounts, what has happened, a timeline of events, and then you did not get the data subject's consent before doing this activity. This basically classifies as further processing, and then this is an unlawful processing of the data subject's personal data. I would expect that the commission would sanction this organization, because so that it doesn't set the precedence for other organizations doing something like this. I still checked the tweet yesterday now, and it's still even active there. So meaning that the organization does not see any wrong in what they are doing, right? But it's important to know that as long as your processing activity does not fall under the caveat of any of the 6 lawful bases, right? And maybe, although you have a contractual relationship, but you need to do further processing that is different from the contractual relationship you have with the data subject, you must get the data subject's consent. It is mandatory. So further processing like this is illegal, except when the data subject fully consents and you understand the risks for processing their activities like this. So it's important to take note of this, and then also ensure that we sensitize our customer care success team, those that basically interface with the customer and get complaints on social media platforms, to ensure that all the activities that they are performing also aligns with the requirement of the Nigerian Data Protection Act. So the second pitfall I'm going to be discussing with you is on privacy policy and data subject coverage. So one of the things I've noticed is that when you review a data privacy policy, you tend to see that a lot of organizations focus their privacy policy on their customers. Now, the Nigerian Data Protection Act is not for customers. It is for all data subjects, all category of data subjects, be it employees, vendor, whatever category you find yourself to the organization that is processing your data. You must, your data and the privacy policy must communicate what your personal data that they collect and what they will be using it for. But you tend to see that privacy notice or privacy policy is tailored more towards customer, and then you don't see and even if you look at the personal data that they collect and the purpose, you see that it's also tied to the customer. So based on this now, as a professional, you want to go back, check your privacy policy, ensure that first of all it accommodates all data subjects. You want to know all the data subjects that your organization collect their personal data, and then ensure that your privacy notice captures each and every one of them, because the privacy policy is not just for one specific type of data subject, it is for all data subjects. Then another thing is that a number of these privacy policy, I guess maybe in a way to not disclose fully, they can be very ambiguous, right? You would not see in details the personal data, what they are processing it for. So now the commission has said that when you are putting out a privacy policy, right, there are certain key requirements, and then you want to know those key requirements. You ensure that all the personal data that you are collecting and what you are collecting it for is stated. Also, let the data subject understand the basis for which you are collecting it, amongst many other things like that, right? So you want to ensure that your privacy policy is detailed, it's understandable, it is clear. The data subject is not confused, or they are not they don't have clarity on certain key things that you are expected to inform them of, because you'll be liable if you don't inform them. So when we are pushing out privacy notice, or when we are reviewing privacy notice, we want to ensure that our customer or the relative data subjects, right, they have all the required information to make a decision based on what they are seeing, right? And then also ensuring that you also put means for them to seek redress with you. So that's the bit on privacy policy and data subject coverage. So lastly, we'll be looking at the deficiencies in the data protection officer training and assignments. So one of the things I've realized is that a number of organizations, they don't formalize their appointment of the data protection officer, and not doing that will also make you liable. And I also want to state that just because you put a data protection officer's detail in the registration form for the commission, it is not equivalent as appointment, because even the commission will not take that from you. You must formalize that appointment with the data protection officer and ensure that there's an appointment memo or letter that you can present as evidence that you actually formalize that appointment and the data protection officer acknowledges their responsibility. Another thing we also look at is inadequate training. You see that most times when you ask for training evidence, it's usually just like most data protection officers usually were not trained, or they were given inadequate training. Just do like maybe a 1-hour course and then that's it. But now the commission is saying that as a data protection officer, you must have adequate competence. Just anybody cannot be a data protection officer. You must be certified, you must have, and the certification must be internationally recognized, or either the certification that the commission themselves is administering currently. And then lastly, conflict of interest. This one is very paramount in Nigeria, and I still don't know how the commission intends to address this, because although the commission is stating now that there must be no conflict of interest, they are saying that you can still carry out certain roles and responsibilities. And now, in carrying out certain roles and responsibility, I feel like perhaps the commission needs to state clearly what can be termed as conflict of interest. Now, as somebody that has done data protection courses, I have an understanding of it, right? But it would be nice to see what the commission's view in terms of conflict of interest is, because obviously, if you are involved in any data processing activity, either be it on data security, data storage, if you are centered around that processing, it creates a bias, because if that your area of processing is the one that is affected, you might not be able to give an unbiased assessment of that data breach, and then it would result in a conflict of interest. So it would be nice for me to see what the commission is saying regarding conflict of interest, because I know that if you go to, even in financial institutions, if you look at who their data protection officer is, you see that they have conflicting responsibility that might impact their responsibility as a data protection officer. So this diagram just basically captures what is expected of a data protection officer. They must be appointed, have expert knowledge. They can be either a staff or a consultant, and their position, they must be empowered with the required resources. They are allowed to have people that can work alongside them to ensure that the compliance measure is effective. They must report directly to the highest level of management. So that's another thing to check when you are looking at the role of the data protection officer. Your DPO must report directly to the highest level of management, and then there must be no conflict, which I just spoke to earlier. Then he also has an additional responsibility on the data protection officer, meaning that as a data protection officer, you must carry out a biannual assessment and report to management. And then these reports will form a part of your ROPA, that's the record of processing activity, as well as, and it must be validated by the Data Protection Compliance Organization when they come for the annual compliance audit assessments that they come for. So that's that bit. And then lastly, on credential assessments, you must be competent, you must be certified, and then you must put in professional hours of 40 credits every year and submit it to the commission. So in wrapping up, what are the mandatory compliance checks that we must do based on what we've discussed so far? First of all, you want to review your privacy policy. You want to ensure it's comprehensive, it's accurate, and it satisfies all the mandatory disclosure that the Nigerian Data Protection Act has said you must disclose. You want to also validate the relevance of the content by cross-referencing it to every data subject that you collect their data, or you process their data rather, and then the specific data that you collect from them. Next, you want to evaluate the positioning of your data protection officer, ensure that they can operate independently, ensure that there is no form of coercion in terms of their role. You want to also assess and mitigate any potential area where conflicts may arise, and then look into that. And then also validate the competency of your data protection officer, ensure they have the required expertise, ensure that they have all the necessary resources to ensure that your organization is complying and is aligning with the requirements of the Nigerian Data Protection Act and the directive. And lastly, you also want to conduct a holistic review of the GAID and the Act, do like a comparison together and establish a universe of the required compliance control. So you want to do an holistic review, ensure that you are capturing each requirement, and then assess your compliance based on what the Act has said and what the directive is guiding you on regarding each sections of the Nigerian data protection. So in conclusion, I will just leave us with basically this word, right? What we need to understand, right, is that data protection law is basically the transfer of control from every organization to each individual. And what that means is that as organization, we must adopt a data subject first approach. A lot of times when we are discussing compliance, you hear the business, the business, the business. When it comes to data protection, it's the data subject that you must think of first, not the business. Your compliance approach must be centered towards ensuring that you are meeting the expectations of your data subjects regarding the Nigerian Data Protection Act, and then ensuring that their freedom is absolute and it's not negotiable, and it is a priority in every processing decision that we take. So it's important to know that data protection compliance is an act of empowerment. It's not just any regulation, it empowers the data subjects, and then you have to put that empowerment and ensure that they are able to enforce their empowerment. So thank you, everyone. At this point, I'll take questions or contributions.
Thank you so much, Bukola. So much to chew, right? So much to chew in a very short time. There are a few questions I see here. I have some of my own. And Akim is saying, what if the data subject has consented either during opening an account and the clause has been made in agreement to terms and condition form, which most users don't read? I think what Akim is saying here is, if I've included this, say, I think maybe, I'm not sure, maybe stop speaking from a banking perspective now. So I have consented to the processing of my data, right? And that is included in the terms and condition for opening my account. Should that be a concern? Akim, I don't know, maybe you want to unmute and speak just in case I didn't capture your comments properly.
You captured it right. Thank you.
Fantastic, fantastic. All right. Bukola, I want to speak to that briefly.
Yes,
We're
yes.
running out of time. Briefly. I think
Okay,
there's
so to answer your question, the terms and condition is not consent, right? There are certain key criteria that enforces consent, right? It must be freely given, it must be informed, it must be specific. So, terms of and condition has a lot of related terms and condition. And it's like you saying, oh, this is the terms and condition of my contract. This is what I will be doing. This is what is expected of you, and this is what is expected of me. But in terms of consent, right, a data subject must consent to each processing activity. So take, for instance, you want direct marketing. You must be able to show that I ticked direct marketing, right? You must be able to show that, oh, I ticked processing sensitive data. I tick this, I tick that, right? As long as you are relying on consent, right, it must be freely given. It's not expected to be attached to any terms and condition. It is also not expected to be pre-ticked for me, right? The organization cannot assume silence or inactivity as a data subject committing to consent, right? So just because you are saying, oh, I put it in my terms and condition, if the data subject cannot directly tick and say, oh, yes, I am consenting to this, you'll be held liable. So that's just what I'm going to say on that question. So a terms and condition is really not consent. It's just you describing the terms and condition of a contract. For you to get consent, you might want to put somewhere in your account opening form where the data subject can actually now consent to that particular processing activity that you want their consent for, but not embedding it in their terms and condition and assuming that that is consent. It doesn't work like that.
That would be tantamount to boju boju for those of us
Exactly.
from this part of the world. Okay, Dewumi says, I think another thing for data processors is to make T&C readable and interesting. As a data subject, how is it possible for me to read 2,000 to 5,000 words? You want to comment on this? Again, it's tricky. I think he's saying that he thinks another thing for data processors is to make the T&Cs readable. You know, those T&Cs, they're like tiny stuff that that are smuggled somewhere, and you know, the data protection seems to, the act or the guide seems to have demystified some of those activities. Is this something you want to speak to briefly?
And so it's still similar to the answer I gave earlier. As much as you have a number of things in terms and conditions, right? As long as it's something that requires the data subject consent, you maybe at the end of all your stories, you must now outline those things, right? And then state, oh, you need to give me consent for this, give me consent for that, give me consent of blah, 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 blah. But not just putting everything in a terms and condition format and then saying I agree to your terms and condition. Aside agreeing to terms of condition, if you see that with the existence of the GDPR, a lot of international organizations, after you agree to terms and conditions for things that require your consent, they would put additional tick boxes for you to actually check that, yes, I am consenting to this. So you can embed whatever you like in your terms and conditions, right? As long as it's legal, it's lawful, and it aligns with the contractual relationship you're entering with that customer. However, when it comes to consent, you must still ensure that the data subject is sure of what they are consenting to. So that means you must, it's not the data subject's responsibility to prove that they gave you consent. It's the responsibility of the data controller, meaning that you have that burden to prove yourself. So if you don't want to ensure you're liable, you also have to put extra measures to ensure that areas where you need consent, the data subject is fully aware of the implication of what they are doing, and then and you can actually show that, yes, aside all my stories, they consented to it, they read this, and then they consented to it. And then another thing is that you must not leave those parts pre-ticked, right? You don't tick it on behalf of the customer. The customer has to use their own hand to tick those boxes themselves. So that's just what I would say to the question.
Brilliant, brilliant. Taiwo is asking, he says, my organization is currently working on a project that requires us to share customer information to a third-party company. What can we do to ensure that the third-party company complies with the NDPA Act, though non-disclosure agreement has been signed?
Okay, so it's not enough to have a non-disclosure agreement. If you look at the guidance and also the acts, there are certain obligations that must be embedded in your data processing agreement, right? And in addition to that, the commission has even mandated that you might, as an organization, you might want to have compliance monitoring, because if your data processor is liable to the act, you are also liable. So you cannot say, oh, I had an agreement, I had this, I signed a non-disclosure agreement. The non-disclosure agreements might just help you in terms of financial impact, but in terms of penalties, reputational impact, you are still liable. So you need to ensure that your data processing agreement covers everything that is stated in the implementation directive and also the Nigerian Data Protection Act. And then you also want to ensure that you are monitoring the compliance of your data processors. Let them, if they are going to be engaging another data processor, you must be informed. You must also understand the extent to which the additional processing to the other data processor is going to be involved in, right? So as a data controller, the Nigerian Data Protection Act is giving you that, it's giving like an empowerment to ensure that you are fully responsible for your compliance. Ensure your data protection agreement covers all the key requirements that will ensure that you can monitor your data processor's compliance to the Nigerian Data Protection Act and then enforce such compliance. If such data processor is not complying, then you might want to ensure that you stop the processing with that data processor, as well as ensuring that all the information that you've shared with such organization is properly deleted and they no longer have access to it. So number one is ensure your data processor agreement covers what is required by the Act and also empowers you as an organization to ensure full compliance of the data processor. And then secondly, you need to regularly monitor them. So that's the two things that you need to do, basically.
Guys, can we do an extra 5 minutes just so we can take the questions? But we're running out of time. I appeal. Because someone is asking, Udo is saying, how can I get certified to meet the requirements of a DPO? He said, I'm asking this in terms of steps and the examination path.
Okay, so I know that the commission at one time trained some data protection officers, but they are not mandating, at least as of now, they are not mandating that you must do any certification and their own certification. But what they are mandating is that your data protection officer certification must be internationally recognized, and it must be issued by a recognized professional body. So you might want to look at the certified data protection officer certification by PECB. You might want to look at there's one by Isaka. Can't really remember the name.
And we're
There
not
are a number
marketing
of
kids, right? Just as disclaimer. Go ahead,
Okay,
Bukola.
yes. So there are a number of international certification that you can take that are recognized, right? And that they also, in fact, demand that you do you maintain such certification. So just do your personal research and identify the one you will settle for, and then just read about it, ensure you read, and then write your certification. And the commission would recognize it as long as it is internationally recognized and it's from a recognized professional body. Until they give further directive that it must be from them, they are allowed to do this.
Great. Mike says, for right to delete, how do you operationalize this? I think he's meaning delete information of data subjects. How do you operationalize this in an organization that does off-site data archiving? I'm sure we've gone to the vault and see the number of backup disks there that have been there for how practicable. Mike, do you want to unmute and ask this question just in case I'm not capturing it properly? Because I have a similar question.
Okay, thank you. Can you hear me?
Yes, please go ahead. Short and sharp, please.
Can you hear me?
Yes, we can. Short and sharp.
Yeah, hello.
Oops. Okay. I'm not sure we can.
Hello, can you hear me? It's funny.
Yes, we can hear you, but I'm not sure you can hear us. So might have to pass. So Bukola, as piggybacking on Mike's question. Hello, Bukola. Piggybacking on Mike's question, I'm going through my SMS messages, right? And I see tons of promotional messages that, to be honest, I don't think I consented to this stuff. Perhaps I went to the shop to buy something and they asked for my details, but that information was not given to me that they're going to keep sending me stuff. I see messages from telecom companies, flooding my SMS timeline, all sorts of messages. What's the way forward, both from an organizational standpoint and the right of a data subject? How do I opt out from, for instance, for SMS? I know you broached on it a bit. And then for organizations who are currently doing this, what should they do differently?
Okay, so in terms of opting out, right, different organizations have different ways you can opt out, but I think one of the easiest ways is to write to them, right? Yeah. I think I tried it. I did a sample with one financial institution. I will not mention the name, and I think as of today, I do not get promotional messages. I've not gotten for like some few weeks, and before they used to send me like almost every day. So you might want to speak, address, write to them, or if they have some, for instance, for email now, I know some of them have the unsubscribe button where you can easily unsubscribe. But when it comes to text message, like I said, it's a bit difficult. So you might network is unstable. Am I still audible?
Yeah, I can hear you. I can hear you.
All right. Yeah. So you might want to write to them. Now, if after writing to an organization and they still do not respond, or they do not address your requests, right? Then you are allowed to take it up with the commission. But like I mentioned, the grievance portal, as at when I checked the commission, there's no portal yet for that. So maybe you might still want to write to the commission, because the expectation is that there will be a grievance portal and the commission will review and in 7 days give you a report of their findings or penalties and things like that. That's right. But
Okay.
pending when that is established, write to the organization opting out of promotional or marketing messages or information, and then if there is no headway, still write to the commission. Then secondly, for organizations that are guilty of this illegal processing of direct marketing, especially the telecoms. I understand that Airtel is, I don't have smart cash, but somehow I get messages from smart cash that I have no contractual relationship with, right? So a number of organizations needs to take a step back, right? Especially on the consent mechanism. You want to review all the marketing or promotional information that you send out and how you send them out. And then you want to ensure that they align with the requirement of the act. So in terms of consent, you want to piggyback. When did I get consent from this data subject? How did I get the consent? What did I get consent for? And then see if they match what the act is saying. If they don't match it, then you want to immediately stop that processing activity and either maybe request consent or find other creative ways to market your information to your customers or to whichever stakeholders that you are marketing to. But the important thing is to take a step back, go through all the mechanisms through which you send out marketing promotions, and then ensure that those mechanisms, they do not in any way infringe on the data subject rights, or they do not make you liable in terms of validating that you actually got the required consent. Because I'm sure if the commission is ready and the sanction is going to be plenty. I feel like it's even affect every and any organization in Nigeria, because I don't think there's anybody that really complies. But that's why the directive is here. The enforcement started in September, so I expect to see that maybe in the coming months or years, the commission will start to enforce, like put serious enforcement on these kind of things and ensure that organizations, and that would make organizations sit up and know that, okay, this is not child's play, and we have to, be more creative in terms of marketing to our customers or to whichever stakeholder it is. So that's just the bit I would say to that.
Okay, we are out of time. Bukola, thank you very much for the time you have spent with us. We don't take it for granted. For those of us just joining our knowledge sharing sessions for the first time, this is the Tech Assurance community, and our core goal is to democratize knowledge, right? We have these sessions on a monthly basis. On the community, if you're not part of it, I'll just quickly drop the link. The first one is already full. This is like the second one, but what we try to do is that we have a talent pool of over 1,000 folks. So if you're new here and you're looking to hire, or you need advisory on the job, this is a place that you should probably be, right? So I'll say, see you guys next month. And thank you for joining. Let's enjoy the rest of our weekend. Bye. The recording will be shared on the community group and it will be uploaded on YouTube. So just stay tuned. It's also streaming on my LinkedIn page. So just in case, you can also, if you can't wait for the YouTube upload, you can quickly check that. But I think this session is worth listening to again, right? There are so many things that have not been unpacked. Something like managing cookies, right, on websites and all of that. We're not able to go into that. But again, hopefully in subsequent sessions, we'll delve into that. So thank you once again, and let's all have a fantastic weekend. Bye.
All right, bye. Thank you, boss.